Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update from the Constitution Bench hearing a batch of petitions challenging the electoral bonds scheme. As you know, the petitioners allege that the scheme results in making political fundings non-transparent as electoral bond donors are kept anonymous. The 5-judge bench comprises CJI Chandrachud, Justices Sanjeev Khanna, B.R. Gawai, J.B. Pardiwala and Manoj Mishra. Today, an intervention application was filed by Dalit Panthers Party challenging the scheme as discriminatory for not allowing parties with small vote share to accept the bonds. But the court refused to entertain the petition, saying that the challenge to the scheme on this ground could not be considered in an intervention application and suggested the applicant file a separate writ petition. The petitioners today concluded their arguments, followed by the respondents. Senior Advocate Vijay Hansaria for the petitioners took the bench through various amendments to the Companies Act, Income Tax Act, etc., to establish the fact that the company making a donation now only had to declare the total amount donated without declaring which party it had donated to. He further explained the concept of electoral trust. He gave an example saying 5 companies could make an electoral trust. The company can donate to the trust. It would reflect that the company made donation to the trust. The trust has to make 95% donations to parties. Through this route, companies can make donations to political parties, and any donor through electoral trust also gets an exemption. Further, Solicitor General Tushar Mehta, appearing for the Union government, said that the scheme was a deliberate attempt to ensure clean money coming through banking channels to political parties and eradicate unclean and black money in the elections. He also said that donors had expressed reluctance in donating by check or other transparent methods as it would disclose their identity and entail adverse consequences. Under this scheme, when funds are given to a political party, the party would deposit them in a designated account. That account will also have to reflect in the statement of accounts of that political party, which will be filed before the ECI. ECI would know that the amount has come by way of clean money. As earlier, in case of cash, nobody knew where the money went and what it was used for. The arguments in the case will continue tomorrow. Stay tuned with us. The Supreme Court has today confirmed anticipatory bail to social activist Teesta Setalvad and her husband Javed Anand, who are facing charges of embezzlement of funds raised to help and commemorate victims of the 2002 Gujarat riots. The Apex Court has confirmed an earlier order granting the duo interim protection from coercive action. A bench of Justices Sanjay Kishan Kaul, Sudhanshu Dholia and Prashant Kumar Mishra was hearing a batch of pleas filed by Setalvad, Anand, the Gujarat Police and the CBI against a February 2015 Gujarat High Court order which denied the couple anticipatory bail in connection with the embezzlement allegations. Also being heard along with these pleas were multiple SLPs arising out of a 2019 High Court order granting anticipatory bail to Setalvad and Anand with respect to another FIR lodged in 2018 after a second round of allegations were levelled against them by a close aide. In another update, the Supreme Court has observed that a witness will not stand totally discredited merely because the testimony given during the trial contradicted the earlier statement given to the police. The bench, comprising Justices Sanjay Kishan Kaul and Justice Sudhanshu Dholia, was hearing an appeal against a judgment of the Rajasthan High Court which had acquitted the convicts in this case for major offence of murder, retaining only charges of rioting, causing hurt and reduced their sentences to the period already spent in jail. The Supreme Court went on to examine the evidence given by the wife of the deceased, who herself was a victim and was seriously injured. The court emphasized that despite some minor discrepancies, her credibility was not compromised, which the High Court had wrongly asserted. One of the key aspects that the court highlighted was the importance of considering social background and overall surrounding circumstances when evaluating a witness's testimony. The court also underlined that the account given by an injured eyewitness should not be dismissed lightly unless compelling reasons exist to do so. Minor discrepancies, which may naturally occur during witnesses' testimonies, should not undermine the overall credibility of the evidence presented. Consequently, the Supreme Court set aside the High Court's verdict. The findings of Section 302, that is murder, were converted to that of Section 304 of IPC, that is culpable homicide not amounting to murder. To read this case in detail, you can visit our website at livelaw.in. The Kerala High Court today directed the state government to issue necessary notifications under the OBC Advocate Grant Scheme for the years 2021-22 and 22-23 to the eligible junior advocates. The single bench of Justice Devan Ramchandran was hearing a plea moved against non-issuance of notification to claim annual grant of 12,000 rupees to the junior advocates belonging to OBC category under the OBC Advocate Grant Scheme for purchasing law books, gown and uniform. The court stated that the government had absolutely no reason for non-issuance of notification under the scheme since 2021, and that the benefit given to the young lawyers under the scheme could not be denied for no perceptible reason. The court noted that young advocates who join the profession face grave financial issues and drop out of the profession due to lack of sufficient support. That the legal system requires successful lawyers, judges, and jurists from such communities, and so the system should support them in every possible way. A Delhi court has slammed the Delhi police for wrongly clubbing 19 complaints in a Delhi riots case without having any sound basis. The FIR was registered on the basis of a complaint made by one Shokin, alleging that his house and shop were set on fire by a mob during the 2020 riots. During further investigation on the grounds of proximity of place of incidents and area, the investigating officer clubbed 19 other complaints in the case. Additional Sessions Judge Pulatsya Paramachala of Karkarduma courts observed that there were 20 different places or different incidents taken up for investigation in one FIR, but none of the IOs had bothered to ask the two alleged eyewitnesses about the 19 additional incidents. The judge made the observations while acquitting one Sandeep Kumar of charges of rioting and unlawful assembly registered at Karwal Nagar police station. The court has ordered that the 19 additional incidents be investigated separately. In another update, the Kerala High Court has refused to grant anticipatory bail to 3 persons who had allegedly cheated a woman by putting up a fake profile on a matrimonial website. The prosecution's allegation was that a 38-year-old man who is already married had put up a matrimonial profile claiming himself to be a doctor and had gone to the house of the de facto complainant with his wife and mother under the pretext of fixing marriage. Allegedly, he obtained 150 sovereigns of gold from the complainant by convincing her that he required money urgently for medical treatment of his father. The man, his wife, and his mother, while praying for anticipatory bail, argued that he was involved in some business relations with the complainant, and false allegations were leveled against him as a result of fallout between the parties. However, the counsel for the de facto complainant argued that the present case was a clear instance of cheating. Justice Gopinath P. was of the considered view that the plea for anticipatory bail could not be granted in light of the clear allegations, and therefore the plea was dismissed. The Delhi High Court will hear afresh the bail pleas of Sharjeel Imam, Khalid Sefai and other accused persons in relation to the Delhi riots' larger conspiracy case. This comes after the elevation of Justice Siddharth Mridul as Chief Justice of Manipur High Court. A division bench of Justice Suresh Kumar Kaith and Justice Shailendra Kaur will start hearing the appeals from January next year. The court was informed today that the verdicts in at least 3 bail pleas were reserved by a special bench headed by Justice Mridul. However, the appeals will have to be re-argued in view of the judge's elevation. And lastly, the Kerala High Court today appointed an amicus curiae in the revision petition filed by deceased social activist Girish Babu against the dismissal of a complaint which sought investigation into the alleged bribery carried out in connection with mining and other business interests of Cochin Minerals and Retail Limited. As the petitioner is no more, Justice K. Babu appointed Advocate Akhil Vijay as the amicus curiae in the matter. The deceased petitioner had accused Veena Vijayan, daughter of Chief Minister Pinarayi Vijayan, and her company Exalogic Solutions Private Limited of having received illegal consideration under the guise of her father. Apart from them, other public servants and political leaders are alleged to have given out bribes for illegal gratification. The Vigilance Court had dismissed the petitioner's complaint on finding that there was no prima facie case and only general allegations were made. So, against the Vigilance Court's decision, the present revision petition was filed. The matter has been posted for further consideration tomorrow. Stay tuned. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.